Welcome to another installment of Better FAQ videos. Today we are talking about trademark, and specifically we're going to talk about the Supplemental Register. Now, a little bit of context required to know what the heck that is. When you go to file a trademark application with the United States Patent and Trademark Office, the USPTO, you file a trademark application, put all the information in there, show them what the trademark is, tell them what products and services you use this trademark with, and then you send it off to the USPTO for an examining attorney to review it. The fun thing about that is that it takes several months before they even look at your application. I like to think that it just sits on these like comically large stacks of paperwork on the desks like you see in cartoons. Probably not, but it's funny to think of that way. Now, once they do review your application, they will then look to see whether or not your trademark is too descriptive. Now, there's really two standards, two thresholds for trademark registration, whether you're eligible to register a trademark with the USPTO. One of them is similarity, which we're not going to cover in this video, and that's the big one. But the other one is descriptiveness. And it's very important because they both are going to be something that can prevent you from registering a trademark. Now, with descriptiveness, it gets a little bit tricky, like everything in trademark. But what we're looking for is whether it is descriptive of the products and the services that you offer. So the easy example that I always provide is, as a law firm, if we wanted to register the trademark law firm for our law firm, that is pretty descriptive. Legal services, similar, too descriptive. But the important thing to mention about this is that when you file a descriptive trademark, that doesn't mean that it is going to be rejected outright, meaning it doesn't automatically mean you cannot register that trademark. What happens a lot of the time, and why the USPTO has this thing called the Supplemental Register, is that sometimes, and often, descriptive marks can still be registered on the Supplemental Register rather than the Principal Register. Now, what does that mean? The Principal Register is what you're aiming for. It's what the goal is when you file a trademark application with the USPTO. You want to achieve a Principal Register registration because that is the register that gives you the exclusive right to use your trademark with your products and services in all 50 states, in the entire country, no matter what. And with that, you're the exclusive right holder for that trademark for those products and services. Now, the Supplemental Register, on the other hand, gives you rights to that trademark, but they are more limited. You are not the exclusive one that is allowed to use that trademark because that would mean that you're the only person that can use descriptive words to describe the products and services that those words describe. So let's go back to the law firm example. With the law firm example, if we were able to register a law firm on the Principal Register, the main one, the goal, that gives you the exclusive rights in the entire country, well, no one else would be able to call their law firm. And that's not fair from a commerce standpoint and also just from an equity standpoint. And so that's why you cannot have descriptive trademarks. You can't take the adjectives away from other people and prevent them from using them. And so when you file a descriptive mark, typically that means it's going to land on the Supplemental Register. Now, the important thing to mention here is that a lot of the time the way that you want to use a trademark registration is you want to send that trademark certificate showing that you're registered and for what products and services to somebody that's using a mark that's similar to yours to get them to stop, right? Well, when you do that with a Supplemental Register certificate, a lot of the time that's enough. People don't realize, or they may not have legal counsel, or they may not understand that the Supplemental Register is not the Principal Register, and they'll see that trademark certificate, they'll understand that you went to those lengths to get that registered, and they may stop using the similar mark because of that Supplemental Register registration. Now, if they do have a lawyer, they're probably going to push back because, again, you don't get exclusive rights under the Supplemental Register. It's like an abbreviated version of rights compared to the Principal Register, but it is still worthwhile. And certainly if you have a name or a trademark that is going to be descriptive and you're not going to change that mark, then you might as well file an application, shoot for the Principal Register, and if you land on the Supplemental Register, it's not a bad second place because you still have rights, you still have a trademark certificate with a little gold seal on it, and you can still use that in limited ways to protect your trademark. Hopefully this has been helpful. The Supplemental Register is a super important thing to keep in mind because of the fact that we have a lot of descriptive trademarks out there for businesses and their brands. So Supplemental Register, not the worst case, but definitely second place. Thanks for tuning in.